Marino?
Yes, Your Honor.
Mr. Batar talked to Ms. Dineski, and apparently she's representing herself. People versus Lindsay Dineski. This is set for the violation of the conditional bond.
This case is the perfect example of what happens when delusion, denial, and defiance collide inside a courtroom. Before the judge even begins the hearing, tension is already high. The defendant enters with a long list of grievances, accusations, and conspiracy-style claims. And she's convinced that everyone, from police to prosecutors to housing officials, is part of a massive plot against her. This opening sets the tone for what will become a chaotic legal journey. Every hearing gets more complicated as she repeatedly interrupts, tries to redirect the court, and fights every procedure. In today's breakdown, we go through the first chapter of this unfolding disaster. And trust me, it only gets worse from here.
And also there's still the underlying case that is that there was a warrant on of the malicious use. What's the people's position on these cases?
Your Honor, as it relates to the bond, there have been numerous bond violations reported by Mr. Nerswick during the pendency of this matter. I believe there were at least 4 that were reported. Mr. Nerswick indicates there were more that he did not report, just so that he wasn't going to the police on a daily basis.
Right, I understand.
From her. It's clear, I mean, she made it clear during the pretrial with Judge Martin that she did not agree to the court's bond and wasn't going to abide by it, and she absolutely has not. There have been continued bond violations. I spoke with Mr. Nerswick for a moment this morning. He indicated that what he would like is no contact from Ms. Dineski, because the limited contact that he did afford her during the pendency of this matter, she has abused repeatedly.
Right, and so there's already a no contact in place and she decides to ignore it. So what would you
No,
like
I
me to
actually
do?
don't. I actually don't. He was harassing me and I only told him
Okay.
to stop harassing me.
Okay.
So if he comes to my home and he's harassing me, I have a right to
Okay.
say, you cannot
Miss
harass me. And the
Manarino.
only other time I talked to him was about the children, which I was told I
Okay.
was allowed. And I do not feel I can get a fair trial here, and I would like a change
Okay.
of venue, and I would like
Okay.
a trial, or I would like the charges to be dropped. I am not
Ms.
guilty of this
Dineski,
charge.
please be quiet so I don't have to mute you. Don't make
Well,
me
I'm
do
letting
that.
you know what I would like.
Ms. Manarino, what's the people's position on all of this?
Your Honor,
And I'm aware that there's some ongoing thing with,
Right from the start, you can see the judge is trying extremely hard to maintain a calm, structured courtroom. But the defendant immediately derails the process with personal accusations. Instead of answering basic questions about bond compliance, she shifts into emotional stories about harassment, threats, and neighbors she believes are out to get her. This is a classic pattern seen in sovereign citizen-leaning litigants, overwhelming the court with unrelated narratives. They believe that drowning the judge in details creates confusion or sympathy, but all it does is weaken their credibility. Judges listen patiently, but they never lose sight of what actually matters: the specific legal issue in front of them.
Yeah, he lied to get a court order. He stole my court documents. He's been harassing me at my house daily. He's had family members harass me. He's had other people texting me that are basically telling me what he wants to say, calling me a cunt, calling me a bitch, saying I'm never going to see my kids again. He's the one harassing me.
your
and he's playing
children
the
stuff is downtown. I mean, that's what,
No, this
that's
is about
what
the
family
children. The whole
court.
reason why he's
But
put
I'm
harassment
saying that
charges on
family
me.
court, I can't do anything
Okay, but he's
about your
putting
children.
harassment, ma'am. Can I just? I'm in. This
No,
is my
actually,
hearing.
it's my courtroom. No, you
No,
speak
but it's
when
my
I tell
hearing,
you
and
you
I'm
can
the
speak.
defendant, and I have a right. I have a
You're
right.
right. You have the right to be muted, because I'm not going to continue to do this with you, Ms. Dineski. I'm not. Ms. Manarino, what do the people think that they want?
Your Honor, I don't know if because there have been so many
I'm
bonds.
not gonna.
I would
I'm
like
not
a
gonna
trial.
lock this woman up. Ms. Dineski, you're pushing all my buttons. Listen, I'm trying to do I'm trying to figure out what Ms. Manarino thinks she wants, because I'm not inclined to put you in jail. Although I am inclined to make you go and get a competency. Because I think that perhaps you have mental.
I can give you a mental eval and a note from my psychiatrist that says I don't.
Now watch this moment carefully. The judge tries to redirect the conversation back to bond violations, but she continues spiraling into tangents. She talks about child services, parents, job loss, even an unrelated eviction. None of these points address her legal responsibilities. This behavior is one of the biggest red flags courts look for: inability to stay focused on a legal question. When defendants start blending multiple personal conflicts into one courtroom session, judges start wondering whether they're dealing with someone who can navigate the legal process properly. These early signs are exactly what lead the court later to consider whether a mental health evaluation is necessary.
But when somebody's being harassed and abused,
But
they
Ms.
don't act like they normally
what I'd
do.
like to do from this, I would like her to have a competency and criminal responsibility.
I would agree
So
with that, Your Honor. I think that would be helpful.
I'm going to make a referral for an out of custody for competency and criminal responsibility.
Well, like I said, I would like
Thank you,
a
Your Honor.
change of venue because this court has shown bias against me and in favor of Chuck. So I would like to change venue.
I don't even know who Chuck is, so it would be hard for me to show bias for somebody
Not
that
you
I don't even
particularly,
know
but this
who it
area
is.
and the police have lied. They lied to have these charges
That
brought,
doesn't
man.
change.
And Your
Changing
Honor-
venue only takes if I change venue.
Yeah, and then
which
you didn't
I'm not.
on the eviction case that we had on the 10th, you did not even allow me a trial, which was my right, and you
No,
evicted me without a
actually,
trial.
you had a 30-day notice to quit, and there was no lease. And I told you if you
There was a lease,
demonstrated
ma'am.
lease,
There
and
was
I
a
gave
lease.
you, and
I had a lease, but I
and
had a
I
lease. and
gave you 24 hours to bring me a proof of that lease, which you did not do. So I'm going to refer this for criminal
Ma'am, you
responsibility and
kicked me out of the room, and you never
All
told me
right?
that I could present the lease, ma'am. You never told me
I
that.
told you that you could present the lease within. Listen,
You
Mr.
kicked
Nesky,
me out
bring
of the
me the
room.
lease today. Bring me the lease today, then.
I will email it. I don't have a
No,
right.
I don't want it emailed. I want it brought live to
Well,
the
then I'll
court.
have to mail it because I don't have a way to get there. I will have to mail it to you.
Then email it to. Then email it to the court.
And not only that, but he's the one harassing me, and he's abusing the system to harass me. I was
Here, the defendant's defensiveness increases. Instead of calmly answering bond compliance questions, she insists she is the victim of a coordinated conspiracy. She believes every agency is lying, every neighbor is plotting, and every authority is targeting her. These conspiratorial narratives are common in sovereign citizen-style defendants who distrust all institutions. The judge remains patient, but you can hear the shift in tone, that this isn't adding up tone. And once the court starts noticing inconsistency after inconsistency, that's when the legal system begins steering towards stricter oversight, including competency evaluations or mental health assessments.
sending my good faith efforts about the ending of our relationship and our children, and he took that, and instead of going to mediation, which is what I was asking him for, he had the police lie on a police report, which I can prove that they lied. I have the evidence, and the thing is my liberty should not be infringed upon because somebody else lied, and I can prove it. So that's why I would like to try.
For today, before I do anything else, they're going to send you paperwork to get a criminal responsibility and a competency to make sure that you understand the charges.
Yeah,
and that
but
you
if I can,
understand,
but you know what? If I can
all
prove that
of your behaviors, Ms. Dinesky.
What behavior? Standing up for
clearly
myself?
Evidence.
Standing up for all I have done is stand up for
Mhm.
abuse, ma'am. You guys are helping an abuser abuse a victim because he has
and
friends
that's your
with
opinion
police.
today, and you're entitled to
Yeah, and I
that.
have the
But I
right-
want to
I
make
have a
sure
right
that
for
you're
you to-
competent. So
Well, I can
today,
prove that
I'm
I'm
going to order the
competent.
competency and the criminal responsibility, and we'll go from there. Ms. Manarino, we'll let you know once she's done that, okay?
Yes, Your Honor. Thank
So
you.
when you get the paperwork, you've got to do the referral for
Yes,
that.
but if I
Michelle,
have evidence
how do
that
we
this
send
was
her the referral for that?
so if I have
Michelle.
evidence that this
I have to
these
check with
fraudulent-
Heather.
Okay. Your
May I say
evidence,
one
you'll
thing?
have an opportunity once we establish that you're competent.
Yes, but
Will-
why should I have to take a competency test if I can prove with my evidence that these are felonious charges?
Here she begins presenting herself as the only credible source, while every other party, including police, landlords, judges, and agencies, is corrupt or lying. This everyone is wrong except me pattern is extremely common in sovereign citizen and paper terrorist cases. Courts take big notice when a defendant cannot acknowledge even the possibility that they might be mistaken. That rigid mindset makes cases drag out much longer because they fight basic procedures, deny jurisdiction, ignore warnings, and often violate bond terms without admitting fault. The judge here is starting to see all the warning signs.
They're
Well,
totally
because
erroneous.
of your behaviors and your antics,
What
we have
what
reason to
behaviors? I don't have
believe-
any antics, ma'am. What antics?
Mhm.
Can you give me a lawful reason why you're going to order me to do
Well,
something against my will?
All of your interruptions and your rantings make me question
not
whether or
ranting.
not, and you've made
What did I
statements
rant
about
about?
having
I
mental health
asserted my
issues.
rights. So you're
So I know that you
retaliating.
have a psychiatrist. I know you have a psychiatrist, which leads
that
me to
should be good
believe that
enough.
there may be some mental health issues.
No, I have
And if your
ADHD.
psychiatrist says you're good, and it's my responsibility to make sure that you're competent to proceed. And so that's what I'm
Yes,
going to
and
do.
I have ADHD.
All right.
Very
And
well
Judge,
controlled, ma'am.
Yeah.
And the thing is,
for
I
Heather, we will send the paperwork to the forensic center. They will contact Ms. Duneski and send her the paperwork as long as we have a good address on file. But that's where they'll send it to.
Okay. Okay.
But
So
what
you'll
I'm
reach,
saying,
because it's
ma'am-
not your psychiatrist. We have the state
yes,
psychiatrist.
ma'am, but
talk
I
to you.
should not be forced to take a mental
I
eval
note your objections.
when excuse me, let me finish, please.
Yeah.
When I'm been asserting my rights, there's no antics. I have quoted laws to you. I have quoted my rights that I'm entitled to under the law. So I don't understand how you could see that as antics.
So anyway, Ms. Daneski, it's you've mentioned the psychiatrist multiple times, and I just think it's everybody. And I do this. This has
Well,
nothing to do with you. This is.
Well, I'd be
to do
happy to
with
provide you. I have a letter that I just got from
Not
my therapist. I
providing
have
from
one
your
from my
psychiatrist. I
psychiatrist,
want
and
you
I have
to
a
be-
full. Can I please just can I have a chance?
Well, except that your psychiatrist is not someone that is.
This timestamp is crucial. The court is trying to determine something simple. Did she violate her bond? But instead, she keeps shifting blame to landlords, mysterious threats, and housing offices she says wronged her. The avoidance of direct questions is a major issue. Judges consider this behavior evasive. When a defendant refuses to answer straightforward questions, the court begins to doubt their ability to comply with future orders. This is where the tension builds. The judge can't force trust, but the judge can escalate supervision, revoke bond, or order evaluations. And you can see the judge slowly leaning in that direction.
Experienced
didn't let
in
me
doing
finish. I have another
competency
thing.
evaluations.
Okay, but I actually had a competency evaluation by the state of Michigan as well.
Okay.
Already.
When was
So
that?
It was 2019.
I suggest that when you get the competency that's
Or
now,
2020.
that you take that paperwork and give that to them.
So I'm perfectly competent. I don't understand, because I'm asserting my rights, why you're retaliating against me and telling me I need a mental eval because you don't personally like the way I speak, or because I have ADD. So you're
it
discriminating
actually-
against me because I have ADD. So that's part of the reason why I interrupt. And so that is actually under the ADA, you're retaliating against me because of my ADD.
It's not retaliatory.
Yes,
There's
ma'am,
nothing
it is.
retaliatory
Well, then
about
can you
sending
please give
someone
me
for a
one reason why
competency.
you're infringing on my liberty by forcing me
Okay.
to do
Well,
a
you
mental
can
eval?
file an appeal.
I
You have that
will.
right. I make a decision and you
the
can
police
file
are
appeals.
corrupt. The police
In the
who are helping
meantime,
him are corrupt.
we're done for today, and you're going
Okay.
to get something from the forensic center, and and you have to go and participate in that process. And obviously you've already done it once, so you know what it.
Yeah, I mean, I don't mind taking the eval. I just don't have a ride there. I don't have any way to get there. And you know,
and I'm not so sure that they don't do them by Zoom now.
And that's fine if that's what they want to do.
Okay.
But you know, this man has made it so he's destroyed my life. And instead of them helping me, these police, they won't let me file charges against him.
And I don't have supervisory over the police department. I don't do anything.
No, but I'm telling you that he has been violating the law, and they won't help me, Judge. They won't help.
This is where things get heated. The defendant claims she's being harassed by everyone, but provides no functional evidence. She repeats stories, changes details, and tries to portray herself as a target of an elaborate scheme. Judges hear thousands of excuses, and they're extremely skilled at spotting exaggeration. When defendants stretch their narratives too far, credibility collapses. The court is starting to see through the emotional clutter, focusing only on what's provable. And what's provable so far? Her behavior is unstable, her answers inconsistent, and her grasp of legal requirements questionable.
I'm the one being abused, and I have witnesses. I've literally all my neighbors. I've had to have people stay with me for my own safety, and he's saying I'm harassing him. And then and just please hear me out. He went to Washtenaw County. He lied about his address on the paperwork so he could go to Washtenaw County because I had a PPO against him, and his ex-girlfriend, who he tried to kill, had a PPO from before. And so he didn't want to go to court in Wayne County because of all these things. And then he started making false allegations about, I was trying to talk to him about our children. And one of our children he took, and I was worried about her. And then the other children he wouldn't support. So me having a good faith effort, and I had a reason to talk to him, would be different if I was just harassing him and threatening him. I was just saying, if you do not, take care of your children and you don't let me see our other daughter, then I will have to take legal action. That is not harassment. That's asserting my rights. And he has abused the system, and he went to Washtenaw County and he filed stuff there with no jurisdiction because he lied on his, then he should not be considered credible. And you can call the court yourself in Washtenaw County and find that out. He's the one who needs a mental eval because he has lied. He has stole my court documents out of the mailbox. I have shadow of a doubt proof that he has done that, and the police will not investigate it. They have refused to investigate federal felonies. He stole at least 4 court documents, so I did not know.
If you can't get Van Buren Township to do it, then you should.
At this point, the judge is realizing this hearing won't be straightforward. Every attempt to move to the next topic is hijacked by unrelated explanations. The defendant thinks she is clarifying the situation, but what she's really doing is demonstrating she cannot follow courtroom structure. Judges need cooperation, focus, and the ability to stay on topic. When a defendant spirals emotionally or intellectually, the court cannot rely on them to manage their own case. This is exactly why we later see discussions about competency evaluations. These moments are the foundation for that decision.
I suggest that you go to Michigan State Police and make the complaints with them.
Ma'am, they said it's not their jurisdiction.
It is their jurisdiction. When there's an allegation against the local police department, Michigan State Police will get involved.
Yes, ma'am. But I tried. I have proof that I tried to. Or the
sheriff's department.
So I'm telling you as a judge that the law is being broken and that your court is being used to abuse me, a victim, and nobody's listening to me.
You will have an opportunity. There's nothing that's happening on this case right now. It's pending still. So there's nothing that's happening on this. I am telling you though that as long as this case pends, and obviously even for your best interest, you're better off not having any contact with them.
Well, no, here's the problem, Your Honor. With this case pending, they're not going to give me custody of my children, which that's the whole point of this.
This case, I've never seen anyone with a case such as yours. It's a telephone harassment that someone
which is why it should be dropped
because of that case.
Well, he's using that, and he used it to get a PPO, a fraudulent PPO. So he's using fraudulent charges that I can easily prove that should be dismissed based on the fact that there was no malicious intent and based on the fact that I had a reason to communicate with him. And so that's protected free speech.
Well, but
And so-
now
and
from
so while
today
this is-
forward, I'm telling you, you shouldn't have contact with him now, though. It's only causing
Yeah,
you
but
more
he
problems.
he has my children illegally. So
But-
he won't
but
even
Ms.
tell me how the
Dineski,
children are.
I
He
mean, the
kidnapped
judge
the
that's in
children.
charge.
Here comes another pattern. She accuses the court of ignoring her, even though the judge has given her more time than most defendants ever get. That contradiction. You're not listening to me while the judge patiently listens, is a hallmark of defendants who feel persecuted even when they are being treated fairly. Once a defendant locks into the belief that the court itself is part of a conspiracy, the legal process becomes nearly impossible. They stop cooperating, stop listening, and start fighting imaginary battles. The judge recognizes this, and you'll notice the tone getting firmer.
The judge that's in charge of deciding where the children go,
Yeah,
that
but
judge is not going to look favorably if you continue to have contact when you've been told not to. I'm just
Well,
giving
and
you
that's
some
fine. I
friendly
understand that,
advice.
and that's fine. I understand that. I don't want contact with him except for about our children. And right now, he is illegally. He's in violation of MCL 7.0 or 7.50 parental kidnapping. He lied.
But that's not I can't do anything about that. Even if all of that's
The Sumter
true,
won't
I
press,
don't have
yeah, but Sumter won't
authority.
press charges against him, ma'am.
But it's in front of a judge downtown that's made a decision,
No, it's
I
not.
imagine.
No, it's not. That's what I'm trying to tell you. Please listen. Please listen. I told you he filed in Washtenaw County, knowingly that he did not have jurisdiction there, and he lied about his address and put a fake address.
Well, then if it's in Washtenaw County,
it
then
was
you have to go deal
I
with
did.
family court there.
No, we don't, because there wasn't jurisdiction, and he stole my court documents, which I proved to that judge, and she had to vacate it. And he lied to the FBI.
Well, then if there's nothing
that court-
pending right now, you need to file something in Wayne County and
And yes,
family
ma'am,
court saying that.
that's my, yes, and I'm
Okay.
doing that. But what I'm saying is that this is going to be used against me, and that's a violation of my liberty because these
Well, you
charges
haven't
are
even
wrong.
filed it yet, so it can't
Yes,
be
I
used
have.
against you.
Yes, I have. I have filed.
Well, you
it.
just said there was nothing in Wayne County, so you're being
No, I didn't say that. I said this.
contradictory.
No, that's not. You misunderstood me. I said what he filed was not in Wayne County.
Okay,
He
okay.
took it and
But if
went
you
to
have a Wayne
Washtenaw
County action, they'll make a decision. But I have a lot of other
But in the
cases today, and I
meantime,
think I've
he has
given you more than
illegally-
enough time.
But you should be able to tell him to come.
This moment exposes one of the biggest problems of the entire case. She mixes real hardships with fabricated details and conspiracy-level assumptions. Judges can sympathize with genuine struggles, housing issues, threats, job instability. But when those real problems get entangled with exaggerated or false accusations, the court can no longer separate truth from fiction. Her inability to stay grounded in facts makes the judge question whether she can responsibly follow court orders moving forward. That's why the court shifts from patience to caution.
To tell me what's going on with the kids. He took two
I can't do
young
anything
children.
about the kids, Ms. Dineski.
Well,
I don't
then
even
how
have
come-
jurisdiction over the children.
But the last judge said I couldn't contact him when it came to Haley.
I
And
said
that's one
that
of my
you can't have
children, too.
contact with him. I can't tell him what to do with the children. That's an issue for family court.
No, but if he's
All right,
breaking the
for
law,
today,
that's the criminal
we're
law,
all
ma'am.
set for today. All right, and
Okay.
you'll look for something from forensics.
Okay, thank you.
On Deborah Cripps versus Charles Nerswick and Lindsay Dineski, that the last hearing, I had indicated that the plaintiff was entitled to possession. I asked if there was a lease. You said that there was not a lease. Ms. Dineski said there was a lease. Subsequent to that, Ms. Dineski sent documentation to the court of text messages from your client indicating that there was a valid lease through September of this year, which brings me back to the conclusion that there's something in writing that your client indicated, even though it's a text message, but that constitutes, in my mind, some type of a lease, unless Ms. Dineski isn't paying rent or there's a violation of that agreement. there is something in writing that says, although it's not a typical lease, there is a written document that says that she leases the premises through, I don't remember if it's September 1st or September 30th, whatever it is. That's a problem.
Here we see her mindset collapsing. She jumps from topic to topic. Landlord disputes, threats, police reports, even medical issues, none of which address the court's direct question. This is not normal courtroom behavior. Judges don't expect perfection, but they expect coherence. When defendants cannot stay within the legal lane, the court must step in to ensure they aren't a danger to themselves or others. This is where mental health evaluation becomes almost unavoidable.
Okay, I think I have a copy, Judge, or someone copied me. I think a text message. I don't have text messages, plural. But
Yes, a text message that says the lease is until whatever, blah, blah, blah.
Yeah, but Judge, there is no signed lease. We don't have any signed lease by the parties.
Well, it's a determination of whether that communication from your client constitutes an agreement for a lease through September.
Okay.
I mean, you're right. If the text had been from Ms. Dineski to your client, I would agree with you that your client didn't agree. But the text is from your client to her.
Oh. I'm not sure what that is.
It's Mr. Beal. Mr. Beal, mute yourself. Thank you.
Oh. Yeah, but Judge, there's no indication of any acceptance of that.
That's to have a hearing to determine whether there is or not.
Oh, okay. Well, that's fine, Judge. I wasn't sure, Judge, when I had filed my writ, because you had indicated at the last hearing that Ms. Dineski would have to provide that within 1 day. I didn't hear anything for...
Right, no, I know. And then she provided a bunch of documentation and then they brought it up. And then, by the time I looked at it, I said, she's got, go ahead and set it for a hearing.
Oh, okay.
But my question to you, I guess my one question to you is, there is no allegation. She's continuing to pay rent, correct?
Well, I think my client could probably answer that, Judge, because I was approaching this as a termination, not as a non-payment. I think
right.
Mr. Nerswick, up until one point, was paying rent, but then there was no rent being paid. So, I mean, you can ask, I have no problem with the court.
Has there been rent paid, Ms. Cripps?
The last time rent was paid was February 1st. So March.
That's what I did ask.
I'm sorry. Let me back up. March 1st was the last time that rent was paid. So April, May, and then tomorrow rent would be due again.
Right.
And they harassed me out of the property, so I haven't even been living there. And I tried to do a goodwill and good faith.
Well, if you're not living there, Ms. Dineski, then
I didn't want to move.
Contesting this
because I was forced out. They changed the locks. They harassed me illegally, mercilessly.
Okay, no, but
This timestamp is a turning point. The judge starts probing deeper because the defendant's statements are becoming increasingly disconnected. Judges are trained to spot when a defendant might not fully understand the proceedings, or might be too unstable to represent themselves. If a defendant cannot communicate rationally, cannot stay on topic, and cannot answer legal questions directly, the court must evaluate competency. And this is exactly why the judge begins laying the groundwork for that possibility here.
let me just stop you. Then you can file a separate lawsuit against her.
Which I plan on doing, but I was
Okay.
forced out of the house.
Okay,
Literally,
but you're
they
not
locked me
living
out.
there anymore,
Well, I
correct?
want to live there. I never wanted to leave. I tried to make an agreement to pay rent with her. She refused to communicate with me. Then they filed the eviction.
So you want to access the premises so you can come post the bond for the 3 months rent?
I mean, I at least want to get the rest of my at the very least. And I would
Okay.
like to.
Okay,
I
then
would
how
like
much
to-
time, how much time do you need to get the rest of your things?
Well, I'm not sure because every time I've gone back there, there's been someone there. I don't even know if my things are there or not. I need to at least go and assess what is there and see what's going on at the property, because I haven't been able to go back there since that I haven't gone back since the one day that you said that the eviction would have taken place.
No. I said I was gonna give, no, I still haven't signed the writ. I'm trying to get you to tell me.
I know, but you gave Charles a PPO against me.
I didn't give any PPO.
That's what it is. I got a paperwork that said that you gave him a PPO.
I
He served me
don't
with
issue PPOs, Ms. Dineski. That's not even humanly possible. I don't issue PPOs. I'm not a circuit court judge. There's the circuit court judge does the
It
PPOs.
must have been a fraudulent paperwork that he had.
It could be.
And I'll send that to you so you can see how fraudulent these people are and how corrupt they are. And I would like an investigation because
I don't investigate. That's not my job.
Well, the police refuse to investigate. So
I can't force they're a different branch of government. There's nothing I can do about that.
It's funny because judges will order the police to do stuff like take my children unlawfully from me.
I did not have anything to do with taking your children either.
No, but the whole entire eviction and the whole entire false charges of the malicious use of the phone.
And I brought you back when you sent the text message that said that Ms. Cripps had given you access to the property.
But you also issued a fraudulent bench warrant against me when my daughter had a blood clot, and that caused the police to arrest me and take my children and give them.
I issued a bench warrant against you because you didn't appear.
I did.
And then when you did appear, I withdrew the bench warrant.
No, you did not. I was arrested falsely because of Charles.
That didn't come from me. The arrest.
Fraudulent. Why did I get a bench warrant when my daughter had a DVT? And I called and I
have no idea.
Well, that's what happened.
Well, I'll tell you what I'm going to do.
So because of that fraudulent warrant, my children were taken away from me.
Mr. Robinson, I'm going to give her 2 weeks until June the 15th. To get her stuff.
Now the judge is practically forced into investigative mode. She brings up reports, documents, and previous statements because the defendant's story keeps changing. Inconsistent narratives are a huge red flag. When defendants rewrite their own memories, shift blame constantly, or alter timelines, courts struggle to trust anything they say. This timestamp shows the judge trying one last time to get a clear, stable answer, and failing.
And I'll sign the writ on June the 15th. So you have 2 weeks to go into the premises. Probably not, but go ahead, Mr. Nerswick.
Yeah, he follows me around and comes.
Well, but if you have a PPO, then any of her stuff is there, then she has to be able to do a civil standby to get her stuff.
Yeah, but is my stuff even there?
Yeah,
and
you have to have the police department go back with you.
He kidnapped my children because of the warrant, the fraudulent warrant that you issued, and so I have a right to have you order a pickup order to get my children back. Because of that warrant that
I don't even have the jurisdiction to do that.
Yes,
I thought you said you went to law school. I can give you the Supreme Court over children.
Anytime my rights are interposed, any agent of the government, and I can assert my rights to any agent of the government. I can read you the case law if you would like, but because of a mistake that was made by this court, the police took my children from me and gave them to him, and he does not have custody of them. He doesn't even have a legal right established to the children because
okay, you can submit that to me and I'll look at it if you want me to sign something.
Yes, please. I would really appreciate
defendant
that.
to
he has kept I just want you to know he's kept the children away from me illegally since May 6th. He has not spoken to me about them. He has not let me see them, and they are 3 and 4, and one of them I was still nursing. So I will send you that, and I would really like.
If you're still nursing a 3-year-old, that's a different conversation.
No, that's not. If the La Leche League says 3 years old is optimal.
I said it's a different conversation. I didn't make a judgment on it, Ms. Dineski.
I'm just saying it's traumatic. The point is it's traumatic for the children.
To remove her property by June 15th with a civil standby.
Well, it was
Writ
gonna
to
take,
writ to issue on June 15th, Mr. Robinson.
So,
it might take me a lot longer than a civil standby to get my things. And
Well, I can't help it. He's got a PPO that I don't have anything to do with.
The
I
PPO
can't
has
tell you
your
to
name
go
on
get
it,
your
ma'am.
stuff.
I think
The
it's fraudulent.
PPO does not, Mr. Nerswick, who signed the PPO? Thank you. Thank you very much. My name's not on it, Mr. Donosky. It's Judge Triplett. Writ to issue June 15th. Yes, Mr. Nerswick?
By now, it's obvious. The defendant believes she is the only rational person in the room. She treats every authority figure like an enemy, every correction as an attack, and every question as harassment. Judges see this all the time in sovereign citizen-style mindsets. It creates chaos, delays, and risk. The judge realizes this case cannot move forward normally. Too much confusion, too much instability, too much denial. This is where the court prepares to intervene more aggressively.
That is not true at all. He's a liar.
That's fine.
And I
I'm
haven't been
just
there in
gonna give her
weeks
2
either.
weeks and Mr. Nerswick, she can either come with the civil standby or she can appeal me. Those are the situations. All right, Mr. Robinson?
Judge, just so I could clarify, you're going to hold off signing.
Yep.
I already filed the writ.
2 weeks.
So. Okay, thank you, Judge.
Yep, thank you. Thanks. Everybody's all set.
Next is Cripps versus Nerswick and Dineski.
Thank you.
Good morning, Judge Steve Robinson, appearing on behalf of Paula Cripps.
Good morning, Mr. Robinson. Ms. Dineski, can you hear me okay?
Yes, sir. Yes, Your Honor.
All right, and do we have a Mr. Nerswick as
Yes, Your
well?
Honor.
All right, thank you. Activate your camera if you've got it, Mr. Nerswick. If you don't worry about it. Mr. Robinson, what are we doing?
Your Honor, I've had an opportunity to speak with both Mr. Nerswick and Ms. I apologize if I'm pronouncing that wrong, Ms. Dineski. Mr. Nerswick is in agreement. This is a termination of tenancy, Judge. It's not a non-payment. Ms. Dineski has indicated to me that she's filing a motion for change of venue due to wrongful prosecution. Not quite sure the substance of that, Judge, or how it relates to our particular case. Like I said, this is done pursuant to a 30-day notice to quit back in February, and that's where we're at, Judge.
Mr. Dineski, explain to me what your motion is going to be about.
Well, I wanted to ask for a change of venue due to, there's other proceedings in this court where I have been mistreated and maliciously prosecuted. They have shown bias against me and in favor of Charles Nerswick and the Van Buren police who have in violation of. And it's this eviction. Well, up until the point where it became before this court, it was just the Van Buren police and Charles Nerswick, and I would say also Miss Cripps because he's related to her. They're cousins, and he attacked me, and I kicked him out.
You're getting off track.
I'm actually this is retaliation. The eviction itself is retaliation.
Okay. Well, that's all right. Well, you're not going to get a change of venue because you think it's a retaliatory eviction.
But then things have happened since then where the court has entertained malicious and frivolous charges against me that don't even have jurisdictional basis or standing at all to be brought. And they've issued a fraudulent warrant for my arrest, and they have sent the police to my house to harass me multiple times. And I just don't feel that you seem like a very...
That's enough. That's enough. All right, Mr. Robinson, we'll spin this off to one of the other judges and the lady can file a motion.
Well, it's not you that I have a problem with, it's the other judges, sir.
No, but Mr. Robinson's law partner is my wife, so that wouldn't be appropriate for me to hear this.
Oh, I see. Well, I think it should be in a different venue because the other
Well, then
judges.
you'll have to file a motion for that.
Okay. Well, I mean, I was going to say, if you believe that you could be impartial, because so far I've watched several of your cases, you do seem like a good impartial judge. And as long as you can assure me of that, then I would be happy to proceed. I just wanted you to know my concerns because I definitely feel like the other judges in this court have maliciously prosecuted me unfairly. And one of them issued an unlawful warrant, which I will be suing the court for.
This is essentially the breaking point. The defendant's outbursts, accusations, and emotional spirals have reached a level where the judge has to take control. The court cannot rely on her self-management, cannot trust her answers, and cannot risk further violations. This is when judges begin seriously considering options like court-ordered mental evaluation, stricter bond conditions, or even bond revocation. Her behavior forces the court into protective mode for the defendant and the public.
I appreciate your assessment of my character, but it would really be a bad idea for me to hear a case that my bed partner, her law partner, is on the other side of the case.
That's understood, sir.
That's not smart for me.
And I appreciate that. Thank you, Your Honor. You are definitely an honorable judge in my eyes.
Thank you. So you'll be able to file your motions in front of whatever Judge Martin or Judge Green this ends up in front of, and they'll hear your motion. If Mr. Robinson wants to argue against it, they'll hear both sides and then they'll make a decision. Understood?
Are you able to dismiss an unlawful warrant in this court that didn't have jurisdiction? Because my liberty right now is being infringed upon by this court. And I can't even leave my home because they have the police watching my house for something I didn't do.
Let me answer it this way. If one of the other judges in my building made a decision, I can't rule on an appeal to that. You can't appeal.
Not an appeal, but I'm attacking the judgment based on the fact that
you've interrupted me 4 times. 4 times you've interrupted me. I'm not putting up with a fifth. I'll just remove you from the meeting. You've asked me a question. I'm attempting to answer it. If you want me to answer it, you have to be quiet.
Yes, sir.
If Judge Green or Judge Martin issue a warrant and you think that decision is wrong, you cannot appeal their decision to me because we're all on the same level as district court judges. If you want to appeal a decision made by a district court judge, you have to take it to the circuit court.
Yes, sir. I'm not asking for an appeal. Let me clarify. I'm attacking a judgment, and there's Supreme Court rulings that say that I can attack a fraudulent judgment or a judgment base that doesn't have jurisdiction in any court at any time. Okay. So I'm proper, as long as I'm properly before the court. So that's why I was asking. Because it's a void judgment.
Before the court. You're asking me to make a decision on a case that's not mine. So I can't do that.
Okay, I understand. Thank you.
Judge, may I intervene?
So I'm making a note in the file that this case will be blind draw to one of the other judges. I would suggest that you file your motion as soon as you can so we don't have to let too much time languish on the file.
Judge,
yes, Your Honor.
Judge, if I may make a request for an expedited hearing date, and without trying to poison the well, there's been several police runs to this residence. There have been people that have moved in. There's been removal of personal property. There's been, we're not allowed on the property to make maintenance or lawn mowing or other matters. So it's really become quite problematic, Judge. So
yes, but I'm responsible for the lawn maintenance, so there's no need for that. Okay. And I've only sold my own personal property and no one else's. So this is not true.
Stop talking, Mr. Nesky. Mr. Nesky.
Well, he's making false statements against me.
All right, goodbye.
What you've just seen is only the beginning of a long, chaotic legal saga. This defendant's refusal to cooperate, constant accusations, and inability to stay focused pushed the court toward major decisions, including mental health evaluations, stricter supervision, and eventually, far more serious consequences. And remember, this is part 1 of a multi-chapter story. Each hearing gets more chaotic, each contradiction becomes sharper, and each legal issue becomes more serious. If you want the full breakdown of the next chapters, including the eviction battle, the competency ruling, the bond violations, and the final outcome, make sure to like, subscribe, and follow the series. More insane courtroom moments are coming,